And let me talk about possession and access for a moment, because I think we've all have gotten at least some communications from a group that's advocating changes such that they believe that there needs to be an increase in possession and access on the part of the obligors, that they ought to have. Do you have any thoughts regarding whether or not that is the basis for that assumption is true? And if not, what should we be looking at?
Well, I could speak to you from our caseload. A great percentage of the people, the parents in our caseload have never lived together, or if they did, it was briefly. We have a good percentage of people in our caseload that were never married to each other. So what we hear a lot when we're at court is usually the custodial parent complaining that the non-custodial parent doesn't exercise the visitation he's supposed to exercise, or that's in the order. So we don't really hear complaints the other way.
Okay.
And that may be the nature of our caseload.
Okay. One of the complaints I hear more often than not is from obligors who have 4D cases that say that things like, well, I was never served with a lawsuit. Nobody ever told me that, there was an allegation that I'd fathered this child, and as a consequence, I didn't show up for court, obviously, and they got a judgment against me, and now I'm having to pay child support for, their allegation is for a woman and for a child that I don't know anything about. Does that happen very often?
Well, we hear people say that, but in practicality, the courts would not let us do that. We have to either show that we've served the non-custodial parent, and for that matter, the custodial parent. If the custodial parent doesn't show, we cannot. Courts are not allowed to let us proceed unless there's proof of service in the court file.
And does that mean personal service?
It would either mean personal service or substituted service. In some situations, we don't use this very often, but in some situations, the obligor, if a process server goes out and determines that the person lives there but they're not answering the door, they can send an affidavit back through the district clerk that requests that if we leave it with someone over 16 years of age or leave it posted on the door, that we believe this will serve the person. Then we have to file a motion to take and attach that affidavit and take it to the judge, and the judge has to review it and approve that before we can even do that.
And that's a 106
yes,
service.
Rule 106.
And is that all that the courts require you to do, is to simply have that affidavit, or do you have to do anything more than that? For example, send notices to the person by certified mail and regular mail and any other method?
Well, although we're not required to, the answer to the question is the judge looks at the affidavit and determines. So sometimes they reject them. They don't believe the affidavit really convinces them that the person may live there. So that's up to the judge. What we do beyond the normal due process is that we notify, even if the person hasn't been served and there's a hearing set and it's coming up, we mail out notices to the parties. We send, if we have their email address or a mobile phone number, we now send out text notices of those hearings. Now, if they showed up for court based upon just notice of a text message, we would still not be able to proceed on those cases because there's no service in the court file. But we use notifications even when we're not legally required to do it.
So you don't get motions to adjudicate it unless you've had that service or the 106 service. You don't do it by certified mail, for example?
We don't use certified mail service for primary parties to the case. No, we don't.
Ms. Kalani, I think, has a question.
I have a question about enforcing the support orders. It says that you suspend or deny licenses, like occupational licenses.
Yeah, the Chapter 232 of the Family Code allows us to either suspend or deny issuance or renewal of any state-issued licenses. So that includes anything from driver's licenses to bar licenses to any state occupational license and recreational licenses as well. We go after a lot of fishing and hunting licenses as well sometimes.
I can understand the hobbies, but their job, how are they going to pay for it?
Well, we never want to suspend a license. We use that as a tool to compel compliance. It's the threat of suspending the license that helps us to get the person to start making payments. Now, even if we do suspend the license, if the person comes and works out a reasonable payment agreement at that point, we're very quick on once we see that he's demonstrated compliance, that we're very quick on either vacating the license suspension order or doing it what they call a stay of issuance of it, which basically lets him get his license back, but kind of holds it over the person's head, compelling them to pay. We really don't want to put people in jail. We don't want to suspend licenses, but we use those as tools to compel people to pay.
I think Ms. Bowers has a question.
Yes, thank you, Chairman. So will there be an increase in the net income used for child support calculation? And is it supposed to go from $8,550 net income this year to maybe $9,000?
Yeah, we're not sure the exact amount because we have to calculate it closer to September 1st when we have to publish the new maximum amount for the guidelines. When we did the calculations a few months ago, it went over 9,000. Yes.
Okay, thank you.